Very good evening, my dear friends. Nice to be with you again in this evening.
Good
And
evening, sir.
today we will deal with the Registered Office Clause of Memorandum of Association. And time permits the Objects Clause. Otherwise, that we will take up on some other day because division wise, topic wise, better that will take the lecture separately. So, in this case, today we are going to deal with the Registered Office Clause of Memorandum of Association, where, like every person requires a domicile, a house, a residential address, or a office address, here also a company has to get its domicile with regard to the office, the situation. The situation of the registered office of a company determines the domicile. So the best example is already I discussed it with you. Daimler Company Limited versus Continental Tire and Rubber Company Limited. This is the most important case which we have already discussed. Basically, you must understand, depends upon the registration, the domicile is fixed. Registration, whether it is in India or in a foreign country. Several foreigners incorporated a company in India, registered in India. It is not a foreign company, it is an Indian company. Registration is the criteria. Several Indians incorporated a company in a foreign country, then it is not an Indian company, it is a foreign company. That is how we have to see. Apart from that, the registered office is very important. Every company must have the registered office. In this regard, section 4, read with 12 and 13, deal with this particular subject matter. That where this particular registered office is concerned. Dear friends, section 4 is the basic provision I have been dealing with, telling you. Section 4, subsection 1, clause B states that this memorandum of company shall state the state in which the registered office of the company is to be situated. In the memorandum, you need not give the address. But in the memorandum, you have to state the state in which the registered office is proposed to be situated. That's the most important thing because the operational admin jurisdiction, the territorial jurisdiction of register of companies is decided based on the registration clause, the registered office of the company. If you register it in Telangana, then the register of companies Telangana will have jurisdiction. You register it at Andhra Pradesh, the register of companies Andhra Pradesh will have jurisdiction. If it is Maharashtra, then it is the Maharashtra. Registrars will be number of persons depends upon the necessity. In Maharashtra, there would be several registrars. One for the High Court also there. Maybe in Andhra Pradesh or Telangana now separated, there could be only one registrar. It all depends upon the administrative convenience and it would be decided by the Ministry of Corporate Affairs. This is the most important aspect. You have to see that the application for registration has to be made with the register of companies. The admin authority is the register of companies. Actually, the regulator is MCA, Ministry of Corporate Affairs, and down the hierarchy, the regional directorate, followed by the register of companies. These are all the officers will deal with these corporates, and directly the officer who will deal with this company's registration, regulation of its conduct, and compliances, all these things, prosecution, everything is the register of companies of the appropriate state. So this is the most important aspect. So here central government means MCE, ROC means Register of Companies. Both play a very pivotal role in administering the corporate affairs. This is what you have to understand very clearly. So friends, section 4, subsection 1, clause B deals with this registered office clause where in the memorandum of association you have to state clearly the state in which the registered office of the company is proposed. Then the next important thing is that the registered office of the company must be stated after incorporation. The clear address should be given. These are all the provisions stated under Section 12 of the Companies Act. Section 12 of the Companies Act. You thoroughly the provisions under 4.1b read with Section 12 and read with Section 13.4 of the Companies Act 2013. Our study of registered office clause, dear friends, is twofold. One is that it deals with the statutory provisions as stated under the Companies Act. The other one is the appropriate case law. What are the judicial decisions pertaining to the registered office? So initially, the significance of registered office, establishing its domicile, the famous English case is relevant. Daimler Company Limited versus Continental Tire and Rubber Company Limited. Then friends, Section 12 contains the necessary provisions with regard to the registered office clause. There are few important issues you have to note down under Section 12. Thoroughly read Section 12 and assimilate. The first point is that under Section 12, a company shall, within 30 days of its incorporation, not commencement of business, incorporation. The date of incorporation is the date of certificate of incorporation issued by the Register of Companies. Here, Register will come into picture, not MCA. Then, within 30 days of its date of incorporation, and all times thereafter, that means within 30 days, then later on, subsequently, all times, it should have a registered office capable of receiving and acknowledging all communications and notices as may be addressed to. Legally speaking, whatever is sent to the register office is deemed to have been served on the company. A notice served on the company, NI, Negotiable Instruments Act, Section 21, Arbitration and Conciliation Act, a suit notice under CPC, whatever it is, a notice sent to the registered office is deemed to be the notice served on the company. And then, second point, the company shall furnish to the registrar verification of its registered office within a period of 30 days of its incorporation in such manner as may be prescribed. That means it should inform the registrar within 30 days the details, and then it should clearly state what the registered office is, where the. Now the most important thing under Section 12, after subsection 8, subsection 9 is now inserted in the 2019 Amendment Act. Now this particular provision says, if the registrar has reasonable cause to believe that the company is not carrying on business or operations, he may cause, who? The Register of Companies. He may cause a physical verification. That means he can physically verify of the registered office of the company in such manner as may be prescribed, and if any default is found to be made in complying with the requirements of subsection 1. What is subsection 1? It shall within 30 days and thereafter have a registered office capable of receiving and acknowledging all notices and communications. The registrar then may, without prejudice to the provisions of subsection 8, subsection 8 is default provision, then initiate action for the removal of the name of the company from the register of companies under chapter 18. That means he would strike off the name of the company, and then he would ultimately remove it from the register of companies, and then the company would become then non-est. So this is the latest provision that shows that you just can't go on, in fact, dodging. 30 days is the time from date of incorporation, you must have a registered office. Then friends, under next point, 3, under the subsection 3 of section 12, every company must conspicuously put the company's name, address, registered office, and all other details, and then with regard to the local language also, and then in and then further one of the languages in general use in that locality also must be used apart from English. Then it should engrave its name in legible characters on its seal, if any, and then on its hundis, promissory notes, and all such things, the name should be mentioned with absolute clarity. And friends, if it is a case of a company changed its name during last 2 years, paint, as the case may be, along with the old name, but don't forget, always the address of the company must be affixed, must be displayed conspicuously. And friends, under subsection 12.4, notice of every change of the situation of the registered office verified after the date of incorporation must be given to the registrar within 30 days of the change. Always it is within 30 days of the change, it should be intimated, and the registrar will record the same. The registered office cannot be shifted except with a special resolution. And then, friends, this is a different aspect. I will come to that. So now what you understand is within 30 days of incorporation, the company must have a registered office and it should be properly notified. And notice of change also must be given compulsorily within 30 days of appropriate change. Now, friends, statutorily, a question under 13, no, before that 12, the section subsection 5 of 12 says, change the registered office from one place to another. The registered office has to be changed from one place to another in the same city, town, or village. In the city, town, or village, a special resolution is required, and then it has to be passed necessarily. That is 3/4 majority. Is from one town to another town in the same state. Also, now a special resolution is required. However, if there are two registrars in a state and from one registrar's jurisdiction it is going to be put before another registrar, then the permission of the regional director has to be obtained. This is the most important thing. However, the confirmation referred to in this particular section 5 shall be communicated within a period of 30 days from the receipt of the application by the regional director. He is to inform this to you, to the company. And the most important aspect is the register of companies will issue a certificate pertaining to the change, and it shall be the conclusive evidence. This is what is the legal perspective. It shall be the conclusive evidence that all the requirements of the Act in respect of change of registered office have been complied with, and then it is a conclusive proof. So far, the transactions are concerned, contracts are concerned, whatever has been done under the earlier registered office and would be done in the new registered office, the binding would be enforceable. Then the question comes, if any default is made, that is without passing special resolution, without intimating, then every officer who is in default shall be. Officer in default is stated under Companies Act. You can go through. Then every officer will be liable for a penalty of 1,000 rupees for every day during which the default continues, not exceeding 1 lakh rupees. So this is the most important aspect, where it is the officer who is liable, not the company. In fact, company also, I'm sorry. And then the company and every officer will be liable for payment of an amount of 1,000 rupees per day of default, but subject to maximum of 1 lakh rupees. Now, suppose it is the change of registered office from one state to another state. Now, this is the most important aspect. If the change of registered office is from one state to another state, what will happen? Within the state, within the city, no problem. It is between one registrar to another registrar within the state, the regional director will give permission, but compulsorily special resolution. If it is from one state to another, then what will happen? It requires, number one, a special resolution, and then it requires a special resolution, and further, it also requires permission from the Senate. Section 13. 4 says the alteration of Section 13, subsection 4 says the alteration of the memorandum relating to the place of the registered office from one state to another shall not have any effect unless it is approved by the central government, that is the Ministry of Corporate Affairs, on an application in such form and manner as may be prescribed. And then subsection 5 deals with the manner of disposing the application for changing registered office from one state to another. The central government shall dispose the application within a period of 60 days. For passing, it may satisfy itself with the alteration has been with the consent of creditors, debenture holders, and other persons concerned, and then been made by the company either for the due discharge of its debts and obligations or adequate security has been provided, and then what for the change is being taken, and then what is the reason, and who are the other persons affected will be taken into account by the particular central government. So the general provision is that basically this particular change of registered office requires a special resolution passed by the company under subsection 1 and rule of the central government if it is change of registered office and change of name. Basically, change of registered office and name requires permission from the central government. Tomorrow, there could be a question on our registered office clause in general or in particular. So what happens is maybe there could be direct questions because of this particular COVID-19. In that event, you have to give all the facts and figures pertaining to registered office, read from section 4.1b, go to 12 and go to 13, subsection 4, 5, 6, and then ultimately you can conclude, and then further the provision under section 10 that no alteration made under this section shall have effect until it is registered in accordance with the provisions of this act. That means once the alteration is given, then under section 7, that is 13.7. Please read 13.4, then 13.5, 13.6, 13.7, and 13.10. Most important provisions. 13.7 is the last provision for alteration. When an alteration of the memorandum results in the transfer of the registered office from one state to another, A certified copy shall be of alteration shall be filed by the company with the register of companies of each state within which time within wherein the earlier it was situated and now proposed, and then the register of the state where the registered office is being shifted to shall issue a fresh certificate of incorporation. This is the most important aspect. Again, he will issue a fresh certificate of incorporation, and no alteration is permitted unless this particular change is recorded. And then, friends, what is most important is normally it is 30 days time that has been given generally, that as we have already seen under section 12, any change, any alteration must be notified within 30 days from the date of that particular change. So here also that provision has to be read with. That is the reason why I repeat again, section 4.1b read with section 12, where I have already brought to your notice section 12, 1, 2, 3, then 4 and 5, then 6 also, then 7, 8, and 9 have to be studied. Read with the alteration procedure under 13. Alteration is covered both under section 12.5 and then again under 13. And then under 13, 4, 5, 6, 7, and then 10. So now you understand, with this, the registrar will issue a fresh certificate of registration, and with that, the company will go ahead afresh, I mean, with the certificate of registration. However, all the old, in fact, the contracts sustain, they survive, and there is no change with regard to cause of action. The territorial jurisdiction, pecuniary jurisdiction of the appropriate cases to be filed under the contracts would not change, because the cause of action arises based on the execution of the contracts where the registered office was situated earlier. For territorial jurisdiction of filing cases, including NCLT, issuing notices, where arbitration cases, 138 NI cases, it is the jurisdiction with regard to registered office clause has to be taken into consideration. So the jurisdiction is most important, which arises out of the situation of the registered office of the appropriate company. So friends, with this background, we have discussed about the legal aspects, the statutory provisions. Now, I will deal with some important cases pertaining to the registered office. Will anybody tell me, apart from issuing notices, receiving notices, and all these things, there is another significance of registered office, an important aspect. Will anybody tell me? Another significance. Any legal practitioner must be able
Company
to.
secretary.
No,
Company secretary will.
no, I am sorry. Tax practitioner, Mr. Murthy, you have to say immediately income tax liability.
Sir.
Am I right? The income tax returns have to be filed where the registered office is situated. Sales tax returns are concerned, that would be all over. Am I right? Because you can sell the properties anywhere, the products anywhere. It is a different concept. But income tax liability is concerned. Income tax liability is concerned. It has to be at the registered office of the company. Am I right?
Yes.
In that event, my dear friends, a question comes. I am contributing, carefully listen all. I am contributing as a company there in Telangana state about 5 lakhs income tax tax payable every year. Like me, there are 1,000 companies. Out of 1,000 companies, 50% of the companies will go to Andhra Pradesh. Then the income tax sharing will be with Andhra Pradesh and Central. And Telangana state will lose the income tax sharing of 500 companies. This is the corporate law you have to understand. Following? If this is the case, how do you justify? Now, Telangana state may say, we will not allow you to go out of Telangana because I suffer revenue loss. As a company, it is for my shareholders to decide where is my registered office and not for the state government. And I am not indebted to the state government to earn income tax sharing for it. This is the most important aspect. So I will now deal with the appropriate case law with regard to revenue sharing and loss of revenue between the states where the registered office of a corporate entity is shifted. Interesting? Is it interesting subject? Very good.
Yes, sir. Very
Everybody
interesting.
is following? Everybody is following.
Yes, sir.
Mr. Khan? Yeah, and how about Mr. Shashirek? Following?
I'm following, sir.
Very good. So now you let us answer this question. A very interesting. Tomorrow examination point of view, 20 marks question, 20 mark का question आएगा. You have to answer this in this fashion. How? The earlier, the court of law declined confirmation. Earlier, the power of confirming shifting of registered office from one state to another state was vested with the high courts. So the courts used to decline, saying that it amounts to loss of revenue. Subsequently, it was shifted to the central government. But that also can be challenged in the high courts or Supreme Court. So the attitude of the courts subsequently changed. I will give you a historical development of these particular decisions in the court of law. I will start with 1957, when I was born. So, in fact, I was not aware that the 57 case in which year I was born would be dealt with before you today. So, let us now take it up. This is called the famous Orient Paper Mills Limited versus Orient Paper Mills Limited versus the state of Orissa. The state of Orissa. And one more important case, Orissa Chemicals and Distilleries. Orissa Chemicals and Distilleries versus state of Orissa. State of Orissa. Friends, in this case, the court of law declined to confirm the shifting of registered office, as it was held that in a federal constitution, the state has got the right to protect its revenue, and therefore the interest of the state is foremost. It should be taken into consideration, so that the shifting of registered office is hereby declined. In those days, the power was vested with the high courts. So this is a judgment of High Court of Orissa. And then a change came subsequently, 1967. Mackinnon, means reference. Mackinnon, Mackenzie and Company. Mackinnon, Mackenzie and Company. In this case, a company was sought to be shifted from West Bengal to Bombay. West Bengal to Bombay. The Calcutta High Court allowed on the contention that the revenue to the Republic of India is the criteria, it is the same. And then revenue, one state revenue loses, another state will gain the revenue. In that event, question of restrictions being imposed for shifting of registered office does not arise. So, in fact, 10 companies may go from Telangana to Hyderabad, Telangana to Andhra Pradesh, and 20 companies may come from different parts of India to Telangana state. So this is a universal principle. It is left to the convenience of the shareholders who ultimately decide. The shareholders' body is supreme, and the shareholders will pass by passing a special resolution will decide as to whether the company's registered office has to be shifted or not, and nobody can interfere. Only when there is any malified intention, and then there is a severe consequences which would follow by shifting the registered office for any other technical or non-technical reasons. Listen, today, the central government, which is the authority, that is the MCA, may decline this particular giving sanction to this particular shifting. Otherwise, it should not. I will take you to a very landmark judgment in this regard. Take down. This is the judgment of the Calcutta High Court. Rank Film Distributors of India Limited. Rank Film Distributors of India Limited versus Register of Companies. ROC, West Bengal, Calcutta. ROC, West Bengal, Calcutta. This is in 1969, Calcutta High Court. You go to Calcutta High Court or you go to the YouTube and then click the citation, names of the parties, you will get the citation and then other details, and then you can see that the actual judgment also. This is a landmark judgment. Some of the advantages is that some particular High Court judgments you go through in depth, you will find a reference to earlier Supreme Court judgments there. This is how, by reading one judgment, you will get a reference of 10 other judgments. Sometimes the Supreme Court judgment also. And then you have to consolidate all, then make out a research paper. So tomorrow LL.M thesis has to be submitted in this fashion by taking this kind of research work. So here also, Rank Film Distributors of India Limited versus ROC West Bengal Calcutta 1969 Calcutta High Court judgment. You please go through. Where take down. The pronouncement is like this. It is the members, that is the shareholders of the company, who should decide, and not the state to decide upon whether the shifting is right or wrong. The body of the shareholders is supreme and it has the authority to decide on the question of shifting the registered office of the company. And further, it was observed the country is one, and indivisible. Most important. The country is one and indivisible. Loss to one state of the country would be balanced by a gain in another state. So we have to take the general revenue to the central government exchequer as the criteria, and then not the individual states, because a corporate entity has its own independent functioning, and the persons who will decide on the appropriate movements of the company, the alterations to the memorandum and articles, happen to be the body of shareholders. Shareholders' decision is supreme. F.C.S versus Arbitrator. The famous judgment I have already referred to. F.C.S versus Arbitrator. So naturally, it is the majority who has to decide, and the majority view will prevail. The majority decision would be binding on the company. And then, in this particular regard, unless there is any fraudulent intention, there is any kind of technicalities involved or a fraudulent intention shown, and then for any other reason, the court comes to a conclusion it is not correct to permit the shifting of registered office. In most of the cases, the courts will not interfere. So here earlier, the power of the court was vested, was shifted to the company law board. And subsequently from the company law board, it is again now shifted back to the central government, that is the Ministry of Corporate Affairs. So, friends, it is the Ministry of Corporate Affairs which would ultimately grant permission. And while granting permission, it cannot go into hyper technicalities, and it cannot go into this kind of extraneous considerations. And it has to take the particular decisions of the shareholders, a special resolution, and then other related aspects. And normally the permission would be granted unless it is an extraordinary case. Then once the particular decision is given, it is subject to ultimately a challenge in the jurisdiction, and then there is no appellate hierarchy here. It would go before it would go ultimately before the high courts, and then this particular decisions would be challenged before the high courts where registered office is situated. So, friends, with this particular background, today we have concluded another important subject matter. This lecture is specifically concentrated on the registered office clause. Yesterday's lecture on the name clause. Day before yesterday, we discussed about Memorandum of Association in general. Today, we concluded our discussion on the registered office clause of the Memorandum of Association. In fact, we have spent enough time today. In fact, tomorrow is a holiday because Sunday you relax. Day after tomorrow, as usual, 6:30 we will meet. I will deal with objects clause of Memorandum of Association. It may take a little longer time because it is a lengthy subject, and then it requires the putting of amended provisions as well as the case law also, and the doctrine of ultravirus. We are going to study that. So for these things, in fact, we will wait for day after tomorrow and then continue. So thank you very much, my dear friends. Any questions, please? Any questions? Okay.
Sir, com-
Okay.
if
Then
a company branches,
yes, Amma.
sir, if a company has branches in another country, then
If a company,
company has branches another country,
uh, if a company,
having branches, sir.
yeah, if company can have branches in other countries, no problem. Then, like foreign companies will have branches here, we call it a foreign company. Indian companies having branches in foreign country, that would be a foreign company for that particular country. Like for example, Glasgow, suppose is incorporated in India. It is an Indian company for us. It has got a branch in US. Then that branch is a foreign company there. In the same way, there are several MNCs today, foreign companies incorporated outside India, and then they have got a branch here. If they have got a sister concern in India, it is a subsidiary, it is an Indian company. If they have got a branch in India, that is called as a foreign company, and that branch it would be taken as if the it is a company incorporated in foreign country, but again came to India so that it has to comply with several requisites as a foreign company, as stated under the Companies Act 2013. So, for this reason, remember once again, I tell you with clarity, a company incorporated in India is an Indian company. A company having incorporated in India, having branches in foreign countries, for those countries, it is a foreign company. A foreign company incorporated in a foreign country is a foreign company for us. And a foreign company branch is in India, it has to comply with all requirements and register with the register of companies as a foreign company only. I hope now you understand. Registration is most important. All Indians start a company in US, it is a foreign company. All US people start a company in India, registered in India, it is an Indian company. Registration is the criteria that decides the domicile. I hope now you understand. Clear? Very good. So, with this background, my dear friends, read the provisions I have quoted. especially first 25, 30 sections of Companies Act thoroughly read, you will get grip over it, and then you will definitely do the best, because they are all the very crucial provisions in the initial stages. So we will progress slowly. We are moving fast, and then slowly we